We continue to read and discuss the Child Care and Protection Act. Alright, part 5. Children detained or brought before a court. Section 63. Age of criminal responsibility. It should be conclusively presumed that no child under the age of 12 can be guilty of an offense. Okay, so 12 or younger, they cannot be found guilty in a court of an offense. But I notice this does not say a child under the age of 12 shall not be guilty of an offense. It says it shall be conclusively presumed. But anyway, why didn't it say straightforward that no child under the age of 12 can be guilty of an offense? Why conclusively presume? Well, that would be interesting. Alright, we continue. Section 64. Determination of age. Determining age. And just to pause here to ask you to subscribe to this channel and comment, like, and check out the links that I've posted under this video. Alright. Okay, so section 64, subsection 1. Where a person, whether charged with an offense or not, is brought before any court otherwise than for the purpose of giving evidence. So if they brought to give evidence, this wouldn't apply, but anything else, it would apply. And it appears to the court that the person is a child, the court shall. Right, so they want to know if this person is a child or not. Make inquiry as to the age of that person, and for that purpose shall take such evidence as may be forthcoming at the hearing of the case. Okay. Subsection 2. An order or judgment of the court shall not be invalidated by any subsequent proof that the person's age has not been correctly stated to the court, and the age presumed or declared by the court to be the age of the person so brought before it shall, for the purposes of this act, be deemed to be the true age of that person. So it seems as if this is saying that if you are 11 years old and the court got information that you were 14, remember, below the age of 12 you cannot be charged. But because the court thought that you were 14, they charge you and find you guilty of an offense. And then after that, they realize, based on further information, that this person is really 11 years old, a child below the age of 12. That earlier order, where you were found guilty, would still be in effect. Alright? It says, an order of judgment of the court shall not be invalidated by subsequent proof of the person's age. Alright. Subsection 3. Where it appears to the court that the person so brought before it has attained the age of 18 years, that person shall, for the purposes of this act, be deemed to be an adult. Alright? 18 years are up. The court sees you as an adult. Subsection 4, the second schedule. Where in any charge or indictment for any offense under this act, or any of the offenses mentioned in the second schedule, except offenses specified in subsection 5. A. it is alleged that the person by or in respect of whom the offense was committed was a child, or was under, or had attained any specified age, and the person appears to the court to have been, at the date of the commission of the alleged offense, a child, or to have been under, or to have attained the specified age, as case may be. So the court says the person who is charged with this offense looks like a child. Alright? The person shall, for all purposes of this act, be presumed at that date to have been a child, or to have been under, or to have attained that age, as the case may be, unless the contrary is proved, unless it is proved that the person is really an adult. Subsection 5. The offences relating to subsection 4 are offences against the following sections of the Offences Against the Person Act. Section 45, procuring defilement of a girl under 18. 48, carnally knowing girl under 12. I mean having sexual relation with a girl under 12. 50, carnally knowing girl above 12 and under 16. 51, including or encouraging defilement of girl on premises. 57, abduction of girl under 16. 58, procurement. 60, abduction with intent to have carnal knowledge. And 61, unlawful detention with intent to have carnal knowledge. And 69, child stealing. Alright, so the offences referred to subsection 4 are offences against the following section of the Offences Against the Persons Act. So remember now, subsection 4 says the person who commit the offence, where in any charge or indictment for any offence, then in the second schedule, except offences. So where in any charge or indictment for any offence under this act, or any of the offences mentioned in the second schedule, except offences specified in subsection 5, except with these, it is alleged that a person by whom this was a child or under it is alleged that the person by or in respect of whom the offence was committed was a child, or under, or had attained a specific age. So that person is at a specified age, maybe 12 or older, or 18 or older, and B, the person appears to the court to have been, at the date of commission of the alleged offence, a child, or to have been under or attained a specified age, then the person shall, all purposes of this act, be presumed at that date to have been a child. Okay. So, here, continue. Every court in dealing with a child who is brought before, section 65, general consideration for guidance of courts. Every court in dealing with a child who is brought before it, either as being in need of care and protection, or as an offender or otherwise, shall have regard to the best interest of the child, and shall, if it deems it necessary, take steps for removing the child from undesirable surroundings, and for securing that proper provision is made for the child's education and training. So the court, if it thinks that the home where the child is living is undesirable, they can remove the child and place that child in a place of safety. Section 66, separation of children from adults. Arrangement shall be made for preventing a child who is A, at a police station in connection with the commission of any offense, whether committed by the child or by any other person. So they're going to make arrangement for that child at the police station, or B, that child is being conveyed to or from any criminal court, remand center, or place of safety, or C, the child is waiting before or after attendance in any court. So the child is either being carried to the court or is in front of the court, in the court. So arrangement shall be made to prevent the child from associating with any adult, not being a relative. So that adult is not a relative of a child, who is charged with any offense other than an offense with which the child is jointly charged. So if the child and the other person work together to commit the offense, then they, in this case, they can associate. This means they can communicate. But if not, if the child alone is charged, or if the adult is charged with an offense against the child, then the court will prevent that adult from associating, or prevent that child from associating with that adult, as long as that adult is not a relative. Alright. Section 67, bail or detention of child. Subsection 1, where a person who is apparently a child is apprehended with or without warrant and cannot be brought forthwith before a court. That means they cannot come into court today. The officer or sub-officer of police in charge of the police station to which the person is brought shall act in accordance with subsection 2. Now, what does subsection 2 say the officer should do? The officer or the sub-officer shall A, they shall so inform the government agency responsible for the care and protection of children. So once a child is arrested, they must write in the book or to send information in some other way about this case to the agency responsible for the care and protection of children. Alright. And B, what else the officer should do? Inquire into the case and may, in accordance with the Bail Act, release the person on a recognizance being entered into by the person or his parent or guardian, with or without sureties, for such amount as will, in the opinion of the officer or sub-officer, secure the person's attendance upon the hearing of the charge, and shall so release that person. So they may give them bail and shall so release that person unless. Alright. So why? Well, give them station bail. But this seems now to be saying that there are certain conditions under which the person cannot get station bail, even though the person is a child. Let's see. One, the charge is one of murder or other grave crime. No station bail. Or 2, it is necessary in the person's interest to remove the person from association with any reputed criminal or prostitute. So, no station bail in that case. Right? prevent them from associating with other criminals or prostitutes. Or 3, the officer or sub-officer has reason to believe that the person's release would defeat the ends of justice. So in those cases, no station bail should be given. Subsection 3. Where a person, apparently a child, is apprehended, so they arrest that person who seems to be a child, and is not released under subsection 2. So they met these 3 criteria, so they're not released. Then the agency responsible for the care and protection of children shall cause the person to be detained in a juvenile remand center until the person can be brought before a court. So they're not allowed to lock up children in the adult jail. They should be sent to a juvenile remand center. Alright. Remand or committal to juvenile remand center. We'll look at that in our next video.